Hi everyone, my name is Dylan Grant and welcome to part 5 of my presentation on Naimark Law Firm, the criminal activities of Naimark Law Firm, Ryan Naimark and Courtney Madison, who joined forces with other lawyers, Morley Law and Nicolini Law Firm, to false represent my cases, It was now Naimark's law to complete its deception, Ryan Naimark and Courtney Madison, 2019 and 2022. Please feel free to pause and read as I go along. I will try to summarize as much as possible. Thanks. September 2020 continued. Statement of claim number 3, wrongful dismissal, Sanford to Mark Law. This was the only statement of claim that I reviewed and signed on May 17, 2019. I also received a statement of defense for the first time in July 2019, which I reviewed and provided feedback. So far, Naimark Law had piggybacked on the other law firms. What have Naimark Law done for me? Former employer, as you can recall, Bell Mobility. The following statement of claim was the correct company name. It has the correct company name and address. Sanford to Mark Law and I collaborated to create the 6-page statement of claim for wrongful dismissal. I am in agreement with most of its contents. I said most because I had a few questions and David Vaughn, Sanford to Mark Law, my lawyer, stated that it can be rectified, okay? I was given a chance to review and sign, all right? As you can see, it says Bell Mobility, Inc. Feel free to read my doodles here, okay? And it says here, May 17, 2019, and there was a person, the court. It says Bell Mobility here with the correct company name and address. This is Out West, 5099 Creek Bank, Mississauga. That's where I worked, okay? And this is the 6-page. Okay, last page here, I'm showing it to you. Please feel free to pause and read if you wish, okay? It includes discrimination, human rights and all that information. And it was certified by the court, as you can see, May 17, 2019. Okay, Sanford to Mark Law. This was a court file number. You notice everything is there? This looked legit with the stamp and everything. Don't you see? I was involved with this statement of claim, wrongful dismissal, issued by Sanford to Mark Law. I signed. This statement of claim was created as per guidelines of the laws of Canada. All right. Naimark Law refused to meet with me in person, via Zoom or phone, to discuss my cases. Instead, they continue to do their own things on their own. Okay. Provided several information to Naimark Law so that they understood my reasons for suing. It was a waste of time since Naimark Law continued to do their own thing. They were not assisting me as their client, but covering up for the deception of the other lawyers and other entities, as a matter of fact, okay? Statement of claim number 4. Why did Naimark Law combine both wrongful dismissal and long-term disability cases? I know I've went through this already on another presentation, but this was the actual time when it happened. I brought those forward for a reason, right? At the time, I brought it forward for a reason. I didn't understood at the time that it wasn't Naimark Law who did this. It was that May 2019 deception by Nicolini Law and Morley Law, who were deceptive, in providing the wrong, deceptive by convincing Benjamin Law and some Faru Law that the Nicolini Law firm was my lawyer, for wrongful dismissal and long-term disability. Wow. No contract signed, okay? But for now, I'm just going to go through as if it was Naimark Law, because this was it at the point in time until I realized after. All right? So the deception number 3. Both claims should be separated since my issues differ with Bell Mobility and my life insurance. Since retained, Naimark Law showed no interest in my cases but deliberately delayed my cases with ridiculous excuses. 1 year and 2 months later, this lawyer had not met with me to discuss my cases but chose to combine my cases to further delay my claims. And as you can see here, Courtney stated September 10, 2020, because after I, the client, asked if I could see the statement of claim. Imagine you're going to an examination for discovery without preparation, eh? I didn't know what were on the statement of claim. Nothing was discussed. Sorry, nothing was discussed with me, right? So here, after I inquired, then Courtney now on September 10th, 2020, stated, take a look at this one. This is the amended statement of claim. The earlier were issued by your prior law firms, and this amended version adds them all together. So the others were issued like from Nicolini Law and also from some Fruta Markin Law, right? That's what she was talking about. So when she said, here's a combined statement, she threw me off there because I'm thinking that the Naimark Law Firm did this, okay? As you can see here, it says the Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Services Inc. and the Bell Mobility Inc. They included, and I will tell you at the time when Nicolini Law and Hicks Morley Law tried to confuse Benjamin Law and some Fruta Markin Law, they said they were in the process of amending the statement of claim by including Bell Canada. Can you remember that? Bell Canada. What Naimark Law did, corrected it to be Bell Mobility. Can you see that? And it was corrected on the 29th of July 2019. Right? Then it says here, pursuant of the order of the Honorable whatever Justin Daly, I think, whatever Daly this is, right? And it says dated the 17th day of July 2019. 17th day of July 2019. I retain Naimark Law on July 11, 2019 for motor vehicle accident claim. Then, so this was prior, this was right. This is dated the 17th. However, I retain Naimark Law for wrongful dismissal and long-term disability on July 26, 2019. Here it says it was amended. The amendment commenced on the 29th of July 2019. How is that possible? Why wasn't anything said to me, the client? Okay, so I'm showing it here that if I had any involvement in my case, I would not have combined them. It should have been separated. Manual life insurance for short-term disability, Industrial Alliance insurance for long-term disability, and Bell Mobility for wrongful dismissal. Okay, I'm sure you would agree with me. Okay, please feel free to pause and read. Thank you. Here I'm saying, why? These lawyers' intent was to confuse my case. All right. All right. They finally got the company name correct from Bell Canada Bell Mobility, but I did not work at the address they indicated. So although they combined the statement of claim, as you can see, Naimark Law still didn't get it because they do have Bell Mobility Inc. 100 Winford Drive, Toronto. 100 Winford Drive is east. I work west. All right. So again, this lawyer didn't know anything about me. The only thing he knew then that I worked at Bell Mobility when I first got there and signed over to his law firm. Please feel free to pause and read. My question here is, they have Benjamin Law on this, right? I'm sure Benjamin Law Firm would not have combined Benjamin Law would not have combined the statement of claim to include Bell Mobility, because at the time Benjamin Law stated that they could only take one of my cases, which was long-term disability. They do not do wrongful dismissal. I believe they do now, but at the time when I went to them, it was not a part of their duty. They only specialized in long-term disability at the time, right? And here, maybe other things too, right? But here they had Benjamin Law, which I believe this is a false representation of the law firm. Okay, please feel free to pause and read. Okay. The section of Naimark law firm continues. So just here, I don't see a file number. I don't see a certified stamp. So was this combined statement of claim legit? As you can see, the statement of claim that I signed with Sanford Watermark in law had everything correct. It has a court stamp, it has the date, it has the file number. What file number would it be if they combine everything, eh? You see the deception? Okay. Please feel free to pause and read because I summarized, okay? I said, however, deception showed that the Justice Daly signed the amended agreement of claim on July 17, 2019, 9 days prior to signing a contract with Naimark Law. I was coerced on July 11, 2019. If this amended statement of claim was legit, where is a certified court stamp? Okay. The deception of the combined statement of claim, recognize this now, originated from Nicolini Law Firm in February 2019 when I decided to take my cases elsewhere. Agent Nicolini deceived Benjamin Law Firm and Sanford Law Firm May 2019 to believe that I had retained his firm, Nicolini Law, right, for long-term disability and wrongful dismissal. Naimark Law, who was aware of the deceit, played their part by correcting the name of the company from Bell Canada to Bell Mobility in July 2019. Claims still not certified by the court. Okay. Nicolini Law Firm, an intent to deceive, 8 months later retained Benjamin Law on February 13, 2019. Remember this? I kept bringing it forward. Okay, so you must remember this. So it says here, they are in the process, a statement of claim against Bell Canada. They were in the process to include Bell Canada. As you can see there, they are amending the LTD statement of claim to include Bell Canada, right? And who did it? Nicolini Law Firm in May. And also it says we received consent in February, right, from the defense counsel. So you know definitely that they were Adrian Nicolini and Hussein Moftaderi, even say Amy Timble, were actually acting to go against me. All right, feel free to pause and read and refresh review again so you can remember that we already discussed this. All right. See amended statement of claim below dated July 29, 2019. The letter that contained the statement of defense did not include the amended portion, Bell Mobility Inc. What was that statement of defense? The Manufacturers Insurance and Industrial Alliance Insurance and Financial Services about? What was it about? I didn't see any statement of defense at all, right? Nicolini Law and the Naimark Law made my cases their own. I am at a loss for what they did to my cases. These lawyers are criminals. Okay, I already went through here. Feel free to pause and read. Okay, thank you. If statement of claim, the manufacturer's life insurance, right, had existed on July 3rd, 2018, that's the date of the statement of claim. Where was the statement of defense for 2018? After the amendment statement of claim dated July 29, 2019 with mobility added, why didn't I? That's a question. Why didn't I receive a copy of the combined statement of claim when I retained Naimark Law in July 2019? Where is the amended statement of defense? if memorability was added in 2019. Retrieve the below letter dated August 28, as you can see here, 2019, via the motion. There was a motion on me and motion against me, right? Via the motion, this was in 2022, from the Ontario Superior Court of Justice. I realized that it was Nicolini Law Firm that was deceitful in May 2019. So, as you can see, there's something here for the manufacturer's life insurance, Manulife for short. Okay, and it says, please find attached the statement of defense of the defendant, the manufacturer's life insurance company, which is served on you pursuant of the rules of civil procedure. So are they dealing with it one by one? Because this is Manulife, and this is August 20, 2019, and I wasn't aware of anything. Please feel to pause and read. Okay, manufacturer's life. So you see manufacturer's life, and it's not combined. This is separate. Okay, so anyone can tell me what's happening here? Please feel free to review. Thank you. And comment. Thank you. Okay. Information on wrongful dismissal to Naimark law. On Monday, August 31st, 2020, right? I had sent this over to Samantha Bray, and I said, please review the attachment for wrongful dismissal. Okay, I've also included a summary of my wrongful dismissal in the form of a Word document that covers all my issues with mobility. I went through this with you already, so I have highlighted a few things here. I've itemized the discrimination that I underwent while working at mobility, right? And it says whatever is stated here. It says no accommodation for 2 months. Okay, then whatever, and this was June in 2016 overall. In July 2016, no accommodation. Whatever this is saying, I have proof no accommodation. I have proof whatever is here, there was no accommodation, right? And whatever I wrote here when I was sent back to work to use my left hand, I have a question: was this an accommodation? If you are right-handed and you are sent back to work to use your left hand, would you consider that an accommodation? Please let me know. Okay, and then I had another question here. I worked for 7 months with my left hand, which became painful due to overuse. See attachment. I did have an attachment. Okay. Was that accommodation? You're right-handed. 7 months using your left hand. Till now, both hands were in pain. Feel free to comment. Thank you. Okay, on September 14th, I got this email from Courtney, WSIB hearing. Okay, Monday, September 14, 2020. Okay, she said, hi, Delane, can you provide us an update on your WSIB hearing? My recollection is that it was supposed to go ahead in late 2020. Why is this lawyer asking me about WSIB? You see, they're trying to play me, eh? Right, because these lawyers know that WSIB and long-term disability cannot go together. She wanted to hear about the hearing, so why didn't she contact Adrian Nicolini? You understand? Or you will say to me and be honest with me to say, you do not have to go through the motion with this WSIB because we have your long-term disability and you cannot file both at the same time. She could have been honest with me. All right, we'll get back to that. All right, I have responded. However, on Tuesday, September 22nd, 2020, right, because I had asked for a meeting, right, they finally are going to arrange the meeting and meeting for the first time. You notice the date, September 22nd, 2020. I have not yet met with the lawyer to discuss my cases. Yet an examination for discovery for long-term disability and wrongful dismissal was scheduled for September 29, 2020. And Courtney Madison had already informed me that my cases are complicated. So if it's complicated, we haven't met. So I was really pushing for a meeting. So the meeting she wanted to, Courtney was thinking of having a meeting via phone. I asked if couldn't we have the meeting via Zoom, right? And so here, Denise sent this. Further to our call earlier, I confirmed the following. I have arranged a prep call for yourself and Courtney for this Friday, September 25th at 2 p.m. As discussed, I will inform Courtney that you have requested this take place via Zoom. A second prep has been arranged for morning of event, September 29th at 8:30 a.m. This was the only time I was given. This was the only time I was given. Okay. Your examination for discovery has been changed to proceed via Zoom. And look at that. It's no longer meeting in person. It is going to be via Zoom. The Zoom that they didn't want in May 2020, saying that it cannot be trusted yet. Look at that. Wow. Feel free to pause and read. Thank you. Okay, this, you can still see September 22nd, 2020. This is the full email that I received from Denise Coy. All right. We did discuss that a meeting was arranged for the Friday 25th at 2 p.m., right? And here, talking about the examination for discovery, September 29th, okay, at 8 September 29th, examination for discovery will be via Zoom, and this was a Zoom meeting. This was a Zoom meeting, so I didn't include it on the first section. I wanted to enlarge things for you to see, but no, this is the entire email with the Zoom meeting for September 29, 2020. No longer meeting in person. Wow. Okay. And then I responded September 23rd, 2020 to Denise, and I said, thank you for the updates. Please advise Courtney that one of my discussions on Friday is regarding the statement of claims. All right. And I had questions. Statement of claim regarding wrongful dismissal, Samfaru to Marken. I had information. It says, I have expressed my concerns with the lawyers since since so much was involved in my wrongful dismissal. As I did say, I spoke with Samfaru to Marken Law, and he said that the statement of claim can be adjusted. All right, so I needed to address that with Courtney. And also statement of claim for long-term disability, nickel law. I stated that nickel law was not retained. So many times I'm saying it, therefore was unaware that a statement of claim was filed within the court. In other words, I was saying that the long-term disability statement of claim was incorrect. All right. And I said here, since we have the upcoming discovery and did not meet in person to discuss, I put it in writing, so I'm not lying on the lawyer, eh? Not lying. I have not met with a lawyer since retaining July 26, 2019, okay? I had asked for a copy so that I could read its contents. I am in disagreement with the information provided to the court. Some information are incorrect. Some information does not relate to my situation, and some information are missing from the statement. All right? I needed to address that. Feel free to pause and read if you wish. Thank you. On September 23rd at 7:42 p.m. Okay, I sent an email. I got an email from Courtney actually. All right. And it stated here, hi Delane, she has been responding, Courtney that is, because I did ask if I could make my comments and forward it and all that. He says, yes, you can provide me your comments in the statement of claim so I can review them before our call on Friday. Statements of claim are generally boilerplate, please. She said, boilerplate, please, which are purposefully overly bored. You hear the words. Purposefully overly bored. Okay, let me tell you now. So, Ashton Steele at Nickel Law stated that statements of claim are usually over the top. That's the word she used. Over the top than what it normally is. That's what she said, right? Here now, Courtney Madison is telling me that statements of claim are generally boilerplate pleas which are purposefully overly bored. You see those who are deceitful will lie and do things against their clients. This is evident because guess what happened? Sam Fruitermark law and which is David Vaughn, that is Sam Fruitermark law. We did a statement of claim together, and there was nothing over the board. It was exactly black and white the way it is, because I had a case and I had the proof and everything was documented in there, including human rights and every single thing, which I was in agreement with. You understand? Give and take one and two little things, which is monetary. That was monetary. You understand? And then these lawyers, Naimark law and Nicolini law, are going to lie for me, and they didn't tell them to lie for me. No, I am not a liar. You're going to say overly bored? No. Anyway, that's so wrong. Okay? And then now, on Friday the 25th, at 1:23, this was before, the meeting was supposed to be at 2 o'clock, eh? I submitted my concerns. I said to Courtney, thank you for your response. Please review the attached statements of claim which contain my concerns. I have made notes on the statements. Right? I put everything in. I said, here, my WSIB hearing did not go as I was advised. I attended the hearing, which was cancelled as soon as it began, since the opposing lawyer brought up an issue which did not relate to the matter at hand. Because I was told by Agent Nicolini law that I need only to prove that my injury actually occurred at work, and I had evidence. Instead, they went again after my medical records. So I told her about the signed consent form that was required and all that. Okay, then I made mention here that I spoke with my lawyer. I spoke with my lawyer. I have not signed the form. I did not sign the form. I stated my reason. I do not know anything about my WSIB case to date. I do not understand what's actually going on. 4 years later, and I'm asked for medical documents that could have been in the position of WSIB, should have been in the position of WSIB since 2017. Feel free to pause and read. Okay, here I'm making you be aware that on my appointment at the Office of Nicolini Law, November 15, 2019, I was told by Agent Nicolini that I could not file both WSIB and long-term disability at the same time. Right? I asked Ryan Naimark when I saw him in person on November 23rd, but he did not give me an answer. I told him about that, eh? Then why was Courtney Madison so interested in knowing about the WSIB case? Why didn't she contact Adrian Nicolini? Or why couldn't she be honest with me and said, I don't want you to get the runaround from this lawyer. Tell your lawyer that you don't need him anymore because you cannot file WSIB and long-term disability at the same time. Since Naimark law was my long-term disability lawyer, they should have guided me as a client and say that I do not need to get WSIB involved. I do not need that lawyer anymore. And they played a game with me. Please continue to pause and read if you wish. Thank you. 25th of September 2020, at 1:26, Courtney responded. And she said, WSIB, because I asked her why she need to know about WSIB, right? So she stated, WSIB award is deductible from the claims you are making. It was please in the defenses. Please have your WSIB lawyer contact me before Tuesday so I understand the status, right? And then to Courtney, I responded and I said, I was hoping that your law firm would have also taken the WSIB case since I thought they were all related. Therefore, thought that all three cases would be resolved in the same time. You had advised that WSIB cases can be complicated, so it wasn't So if it wasn't retained by so it wasn't retained by your law firm. When I met with Nicolini Law Firm in November 2019, I was told to inform my lawyer, Naimark Law, that I will enlarge in the meantime, that I could not file a claim against WSIB and long-term disability at the same time. My long-term disability case was over a year old when I was enlightened with this information. I had informed Mr. Naimark on this situation. So I informed Ryan Naimark, and now I'm informing Courtney Madison. They didn't give me the time of day. Please feel free to pause and read. Okay, thank you. I brought this one forward again for your review because my long-term disability information has been incorrect. It's incorrect. Okay, Industrial Alliance here, who is responsible for long-term disability, as you are aware, that my short-term disability benefits have been suspended as of April 2nd, 2018, effective, right? So my short-term disability should have ended. That's what it says here. Proof: your short-term disability cycle will end on May 1st, 2018. Should have. Okay, so Money Life owed me for 1 month short-term disability. However, my long-term disability should have been since March 2nd, 2018. When I asked my supervisor for my long-term disability information, my supervisor actually provided this, which I recognized that I was placed under a different benefit plan, right? Long-term disability benefit plan. It says I was hired after July 1st, 2000. This anyone after 2000, anyone got hired 2000 and onward, right, do not receive certain perks. I was supposed to be in a different category because I was hired since 1998, right? So the good benefits stopped right up to 1999. So anyone after 1999 does not receive the proper benefits, the perks. So I was cheated by Bell Mobility. Okay. However, I am not a long-term disability, but if I should have won the case, this information is incorrect because this is not what I'm supposed to get. Feel free to pause and read. Thank you if you can. Inform Naimark Law of false statement of claim. All right. So on February 1st, 2020 at 4:09 p.m., right? You have already seen this. I've told Naimark Law, Ryan Naimark, I think 3 times since retained, since July 26, 2019, that I did not sign a retainer with Nicolini Law Firm for disability or wrongful dismissal cases. It could be now my 4th time, I tell you. Okay, please feel free to pause and read. Thank you.